Okay. I'm ready to go whenever you are, Sasha. And Jesse. Oh, excellent. Good morning. It is Tuesday, June 11th. Welcome to today's meeting of the Law and Policy Committee of the California Fair Political Practices Commission. Ms. Linker, will you please take roll?
Commissioner Baker.
Here.
Chair Silver.
Here. Why don't we start with item number 1, and that's going to be public comment for items that are not on today's agenda. Hearing and seeing none, we're going to move on to item 2, and that's going to be approval of the May 2024 minutes. Commissioner Baker, any edits to that?
No edits. Thank you. Move to approve.
Second, any public comment on item number 2? Doesn't look like there is any. So Ms. Linker?
Commissioner Baker.
Aye.
Chair Silver.
Aye.
The motion passes.
Excellent. Well, why don't we move on to item 3 with our senior FPPC Legislative Counsel, Ms. Nakano. Good morning, Ms. Nakano.
Good morning, Chair Silver, Commissioner Baker. Nice to see you both. All right, I'll get right into it. There's 19 active FPPC-related bills. All of the bills are going through the Policy Committee process in the Second House and will be heard in those committees over the next few weeks. Moving down the list in the report, I don't have updates for everything since a lot of them will still be are waiting on being heard in their policy committees, but I'll go through the updates that I do have today. AB 1170 by Assemblymember Valencia relating to electronic filing of Form 700s passed unanimously in the Senate Elections Committee last week and was amended. The amendments make technical changes and require the filer's personal residential address to be redacted from the online copy of the Form 700 posted on the FPPC website, to the extent that it is posted on the website. We are continuing to work with interested parties on this bill, and we expect forthcoming amendments that add some clarifications and detail regarding what may be redacted from the online copies of the statements and when personal residential addresses may be excluded. AB 2001 by Assemblymember Gallagher relating to minor changes to the Political Reform Act. That bill is being heard in the Senate Elections Committee this morning. It's on the consent file and is expected to pass. SB 1404 by Senator Glazer relating to lobbying audits and a new lobbyist fee. After additional analysis from the audits division or the audit division, we discovered that our initial workload projections were overly ambitious. Consequently, we are reanalyzing our fiscal on the bill, as well as developing proposed amendments to reduce the workload to a more manageable size. I may have more certainty and detail on those potential amendments this Thursday at the Commission meeting. I'm skipping down to SB 1170, though happy to return to any of the other bills if there's questions or any feedback or discussion. SB 1170 by Senator Menjivar relates to the use of campaign funds for mental health expenses. That bill was amended last week to make several changes. The bill applies now to all candidates, not just non-incumbents. The candidate may use campaign funds for for mental health services if 2 conditions are satisfied. Those are the candidate doesn't have health insurance or their health insurance doesn't cover the full cost of the services. And 2, the candidate has experienced harassment, prejudice, or a threat or criminal act which resulted in the need for services, and those terms are defined in the bill. The bill changes the time period during which funds may be used for a successful candidate. Funds can be used under the bill starting when the candidate committee is established and to the date that the Secretary of State certifies the election results. However, if the candidate is successful, they can use those funds up to the date that the candidate is sworn in.
Thank you. Commissioner Baker?
Thank you. Noticing my twitching over here. I appreciate that. If it's okay to, so 2 things have come to mind since we last visited, and one, just as you mentioned, some of the amendments. Regarding the amendments, that of the 2 conditions, one of them is that they may have health insurance, but it's not fully covered. For example, somebody may have a copay or whatever. Does that include both, is the idea that it's, potentially a meeting with the professional, like a visit, as opposed to a prescription or other substance? And secondly, is there any possibility, because if this passes, my personal belief is I certainly understand the need for it, but it's as I've expressed before, I see some real problems with its consistency with the law. If we're limiting how much that is, so maybe only the campaign, if they have health insurance, that doesn't pay for all of it if the campaign dollars would only be for the delta of what's not paid for, maybe the copay. So I wonder if you can address either of those two.
Yes, thank you for the questions. For the first question, the scope of the bill, what kinds of services are covered, that's defined to include only counseling and therapy services. So it wouldn't include medications or any other kind of supplemental mental health services. And then the second question was regarding if their insurance doesn't cover the full amount.
Yeah.
Logistically or practically, I'm not sure. I suppose if there was a cap on what their insurance covered for those kinds of services, then they would be able to use campaign funds for whatever the balance was.
Well, I think I'll stick with those two for now. I knew what the second one was. I didn't completely forget it. So sometimes there's a lag lots of times when doctors' bills come and then they're processed by insurance. And I'm imagining scenarios where committees have to close because they need to transfer and reopen to a new one. I'm assuming all the rules that apply for those situations where there's maybe a delayed bill or you don't know the final amount for a while will be the same as any other, I want to say, vendor or cost that goes to a committee, that none of the rules would somehow be applied differently. And it's really to just look at that, have the authors team and maybe Ledge Council on their part look at that and make sure, because medical billing is such a, frankly, screwy world, and you can have a year go by before something is resolved about how much you owe, and maybe you've closed the committee at that point. Maybe the burden will be on the committee officer to decide how they're gonna handle that, if it's worth the administrative mess. I just want to make sure there's nothing in the language that is somehow going to make the process different that we don't already see coming. I thought about that one a little while ago because I was dealing with medical billing. Thank you.
I think those are really good points, and I think that kind of goes to just how much advice we're going to have to provide on this, just like any new law, right? So it's certainly something we want to consider with this legislation. Also, just a quick update, have we heard anything back from the Attorney General's office as to whether we can get access to the opinion letter that we've discussed at prior meetings?
Oh, I've been in contact with the Attorney General's office, and they've been scouring what they have. So far, I haven't heard that they found anything completely on point. I think it might have to do with the fact that at that time they were considered private opinion letters, and so they were maintained in a different way and may not be available to us. So have not found that exact one. They have found general things in the area of personal use, but nothing quite on point.
Perfect. Thanks for that update. Anything else on this item?
Okay.
Okay. Any public comment on SB 1170? Hearing and seeing none, you can go ahead. Ms. Nakano?
Okay, I'll move on to SB 1476 by Senator Blake Spear. This relates to the State Bar of California. The bill was also amended last week to better effectuate the intent of the bill. The amendments clarify that designated employees of the State Bar and members of the Board of Trustees of the State Bar are subject to the PRA's general conflict of interest provisions and must submit Form 700s consistent with their respective conflict of interest codes. Moving on to the three bills that amend Section 84308, AB 2911 by Assemblymember McKinnon, SB 1181 by Senator Glazer, and SB 1243 by Senator Dodd. Commission staff have recommendations for these bills, in particular SB 1243, and we'll be working in conjunction with other stakeholders and legislators to try to come to some consensus about what amendments should be made to these bills. Staff recommend codifying the definition of pending that's in regulation. SB 1243 codifies the definition of pending, but only partially, such that a matter is pending only if it has been placed on an agenda. The current definition in regulation also provides that a matter is pending if the decision is before the officer for their consideration, so much broader than just being on the agenda, or the officer knew or had reason to know about the proceeding and it was reasonably foreseeable that the decision would come before the officer. So the definition in the statute leaves off that second part. Commission staff are open to modifying the definition potentially to eliminate the or had reason to know about the proceeding element. This means that for that portion of the definition, a matter would be considered pending only if the officer actually knew about the proceeding and not merely had reason to know. And this is to try to make it a little bit more workable for officers in that context. Staff recommend keeping the 12-month period of the contribution limit that is an existing law. SB 1243 would shorten it to 9 months. Staff recommend raising the contribution limit potentially to $500 from $250, that's current law, though other amounts are in consideration, and we're discussing what is reasonable in this context. Staff recommend reversing the 2 changes in SB 1243 relating to agents. The bill provides that the contributions of agents shall not be aggregated with those of parties or participants, and also provides that agents are prohibited from making contributions while the proceeding is pending and for 9 months after the final decision. Staff have also heard from the regulated community that compliance is very challenging with regard to participants for multiple reasons, including that officers often don't have notice of which participants will attend a hearing until the day of the hearing or until that person comes to speak. To address this, staff recommends that the definition of participant be revised such that a person is a participant only if the officer knows that the person has a financial interest in the proceeding. Currently, a person is considered a participant regardless of the officer's knowledge. Staff have also spoken with city attorneys about many unique issues that they face and are recommending or are considering a recommendation relating to a limited exception for elected city attorneys. There are 11 elected city attorneys in the state. And open to any discussions, feedback, questions.
Great. Well, thank you for that breakdown. I think each one of these items that you identified are important, are different items that we want to push for. I think they're reasonable. I don't think they're arbitrary. I think the 12-month period, for example, I just think that's easier to remember than 9 months. I don't think there's very many requirements in the act that are 9 months, and really a lot of these changes that we want this office to make are just meant to make this easier to advise on and really easier for everybody involved with advising on and complying with this rule. So I'm in support of this, and I'm really looking forward to seeing how the legislature and the regulated community reacts to these recommendations. Commissioner Baker?
Thank you. Definitely hope there'll be robust discussion and input from the regulated community on this. I'm sure there is. So it was a bill that went through originally without very much hubbub, and we got it all after the fact. So I do have, I just want to sink in a little bit more on a couple of the points. Can you say more about the potential change to the city attorney provision and why that is being looked at, that it will, it's narrowing to whom it applies? Why would elected versus not elected make the difference there? Elaborate on why that change is being considered, please.
I think I don't have all of the background on that before me today, but I can be prepared to talk about that this Thursday, if that's all right.
That's just fine. Of course, we have a meeting in 2 days after this, so we can go into more detail. But that is what I'm interested in, is why we would be carving that out, what they're asking, what is the rationale? I see Director West grabbing the microphone. Chair is all right.
I'll just chime in. Glena West, Executive Director. I believe the thinking behind it was when you're an appointed city attorney, you can choose to run for another office, whereas a city attorney has to run for another office. And so since it's a requirement of the job we were looking into, is that something that should be considered? As Ms. Nakano was talking about, these are all just things that we're trying to consider and figure out fixes for. So we're looking into that as if you have to run for the position that you hold, should your contributions also be treated a little differently, because then it's a requirement of your job almost. And now Dave will take it over.
Okay.
We're tag teaming this one.
Yeah, Dave Bainbridge. I would just add in that the attorney's in a unique position as well, in that part of what their obligation is to advise on contracts. Sometimes they have requirements. I within their job duties that they have to advise the bodies on contracts. So I think attorneys are unique, and then elected attorneys are especially unique because they have these job obligations. They also, in order to get their job, have to run for office and necessarily have to receive campaign contributions. So that was our thinking in discussing this with the city attorneys, particularly the elected city attorneys, why we think that may be a unique group that would justify what would end up being a very narrow exception because, like we said, there's 11 of them in the entire state.
And so the idea is, because I benefit from examples, if you have to run for office and somebody has contributed to your campaign and you're about to advise the city council on something, you may not be able to participate in the advice. What was the limitation that it would put on them that we're trying to say isn't quite right?
Right, yeah, if they are tasked with advising the city council on the proposed contract, they can't do that if they've received a contribution from the party.
And I guess the additional thing that's different about attorneys is they have professional duties of loyalty and fiduciary duties to their clients that they would be violating anyway if they were putting a campaign contribution in their mind first and foremost above their legal duties, unlike candidates in general. So perhaps that's an additional point to be mindful of. Okay.
Yeah, and what we had heard from an elected city attorney is they had just shut down their fundraising completely because of this, because of the great concern with the number of contracts that go through their office and go before the city government. So it was really prohibiting them from raising campaign funds. Again, this is, from our discussions with them, this was an issue they had identified that we had been trying to discuss with them and see if there was, maybe some place where we could reach that we thought was still within the purposes of the law, but address their issue.
And are you looking at completely exempting them from the provisions, or remind me again what the potential
Yeah, the
fix is?
suggestion had been to exclude elected city attorneys from the law.
Okay. If I may, the other follow-up question. So it sounds like in two areas that's being proposed, that actual knowledge is going to be the focus as opposed to you had reasonable reason to know. And I remember going way back to the discussion of the regulations that you had reason to know came up, at least for my part, when, it's been covered in the news, or it's just reasonably foreseeable. Everybody could have seen it coming, but, or it was told to staff, but maybe there's protections to make sure that the elected doesn't know. I was bringing out the full conspiracy theorist in me for this. I would just look, be monitoring how those changes could potentially create a loophole is always the fun language people like to use, but could create a problem. And because I may ask about them again on Thursday as the language continues to develop. I just really want to watch for that. We had quite a bit of discussion about charging officials with reasonable knowledge as opposed to actual. And I think your summaries were in two areas. One was on actual knowledge that someone has a financial interest for definition of participant, which seems odd to define participant based on what the elected knows. I'm assuming that's the best way you can come up with it, but it's odd to change a definition for that point. And I think the other area was, maybe it was in agents, can't recall now, but there were two areas where you mentioned that was it. That's my rambling feedback a little bit for that, because I just remember how much discussion we had to try to not create a circumstance where there's a little trick to get around it. And make sure we don't do that. Thank you.
Excellent. You can go ahead, Ms. Nakano.
Thank you. That actually concludes my update today. If there's any other bills that the committee would like to go over, happy to talk about those.
Excellent. Any last public comment on this item? Hearing and seeing none, why don't we move on to item number 4, and that's going to be discussion of items for the next committee meeting. I don't have any items to add. Commissioner Baker?
I don't have any that we've already put in the good hands of our team to be following up with us on, and I'll look forward to that.
Excellent. Thank you. Well, then I move to adjourn.
Second.
Excellent. Public comment? No, we don't public comment on adjourn. That's good to know. So Ms. Linker?
Commissioner Baker,
Aye.
Chair Silver.
Aye.
The motion passes.
Excellent. Thank you.